transparent. We will be releasing all of the reports and materials that were acquired during the investigation into this matter. Now that it is a closed investigation, that will be made publicly available on our website. That will include statements as well as the unredacted video of the incident, and we will make that available to all the media as well. Now turning to rules, the common person or even maybe the media doesn't know that there are rules that we have to work within. Our cases are not tried in the court of public opinion. They are tried in courts of law, and there are certain laws that limit our ability to file cases, but do so for the benefit of personal security and personal interest. One example is that if you are arrested, we have to charge you or bring you before a magistrate judge within 48 hours, or else the case will be dismissed. So you may look at that as a technicality, but that is something that our prosecutors have to deal with and make a decision on how to proceed. If they do not believe, they will be able to file a case within 48 hours. That's just one example of a rule. Speaking of rules, there also are specific rules for a police officer or law enforcement officer's use of force to effectuate an arrest. And our laws recognize that you and I are not the same as a law enforcement officer who was out there trying to arrest somebody. And what our laws say is a police officer is justified or can use force to effectuate an arrest if it is immediately necessary to do so. This is where there's a little bit of a wrinkle, because and the purpose of the rule makes sense. It's a very common sense, is that law enforcement officers who wake up every day, they don't know what's going to happen. They go out and they effectuate a routine arrest, and in a split second, things have changed, the situation has changed, it's escalated, and now what looked like it was going to be a simple arrest, now there's the requirement for the use of force. So our law recognizes that police officers often have to respond and react, make split-second decisions on how they're going to carry out their duties. Justification under our law is it's a defense, which means that we would have to prove beyond a reasonable doubt that an officer who used force was not justified. And I'm going to repeat that because people seem to think that beyond a reasonable doubt is an easy standard to meet. This is the highest burden under the law. And not only would we have to prove that a crime was committed, we would have to prove beyond a reasonable doubt that an officer used excessive force. Okay? We did our investigation independent of anything GPD did. Chief Prosecutor O'Malley will get into the details of that. But just so you know that if we had proceeded to trial, that is the burden of proof that we would have had to have met. We would have had to have proven to 12 people or 6 people that the use of force that was used in this case, beyond a reasonable doubt, was not justified. So with that, I'll turn it over, unless there are questions for me specifically on what I've covered. Okay, I'll turn it back.
Good afternoon. A couple of points I want to cover at the beginning here and make it very clear. And everyone understands this, but it's a good thing to repeat. Police have a dangerous job, okay? And the public has to remember that, the people have to remember that, and it is important when a person is placed under arrest, comply with the officer's instructions and orders. His job is dangerous. They have that authority to use force, to effectuate arrest, and to gain compliance of an individual. It's for their safety and for the safety of the public. So please, when an officer is approaching you and is placing someone under arrest, comply with that officer's orders. I want to make it very clear from the outset, and I believe our record stands, this office has not shied away from charging police officers with a crime if there is probable cause to do so. We will continue to do that. If probable cause exists, we will charge anyone who we believe has committed that crime. And as egregious as the edited video appears for those who watch that, our independent investigation was conducted by our chief investigator. We talked to all the people at the scene, the lifeguard, the tourists who were there, other police officers, and even the person who actually took the video, and it was determined that the officer's actions were justified and within reason, and for that reason we believe there is no probable cause to charge the officer with any crime. As a conclusion of our case, we have closed the case, and that's why we're going to make available all of the investigators' reports. Thank you.
Can you give us any details right now of the investigation, how you determined this?
We looked at the video many, many times. It was determined that the individual was resisting and he was refusing to get back into the car, and the open palm slap to the abdomen is perfectly allowed. It's allowed under the police rules, and is almost like the most minimal use of force to gain compliance. And when you look at the video, you can see, if you look carefully, you can see where the individual has kicked the car in order to avoid being put inside the police officer's vehicle. And so that's why we felt, based on that and talking to the other individuals at the scene, it was justified police force.
Doesn't the video show that Officer Joey Uggan used a closed palm, a closed fist?
No, we have confirmed. You can't see that in the video because you always see the back, and there's an officer between, there's a car door, then an officer, and then Officer Uggan, and you cannot see you see the arm coming down, but the people right there who were in ability to see the actual action all confirmed it was open palm.
You're talking about the police officers who were behind him.
Well, it's police officers, but we also talked to the lifeguard. If you look at the video again, you'll see the lifeguard was not in a position to actually see what was happening, but everyone who was at the scene confirmed it was open palm.
We have the video, so we can actually watch it, and we can.
And it's fast. And what you need to see is you'll see us bring his leg, it goes up, and now it's bringing it back down. That's when he kicked the car.
Have you considered that with that kind of force, using your arm to swing, that if that was an open palm, he would have broken his wrist?
No, it wasn't hit that hard. And it's to the individual's abdomen.
So the only witnesses to the open palm would be the police officers and maybe the lifeguard?
Yes.
You guys have spoken with the FBI on the status of their investigation as well?
That's their independent investigation.
So you have not?
Why is the AG coming out with all of the investigative documents and making that public when this was a personnel internal affairs investigation?
So we did our investigation independent of any administrative review, and I guess also to clarify, this is just for criminal charges. So the Guam Police Department still has, they will conduct their review, and if they decide that administratively something needs to happen, that will be part of their personnel action. So we have said that we do not feel as though we could prove beyond a reasonable doubt, based on the video, and I guess to the question there, if people can disagree over whether or not he used an open hand or a closed fist, that's reasonable doubt. And that is a struggle that we would have. If there was a video of him with a closed fist punching, then obviously it would be a different thing. But based on the video, based on the statements of the police officers who were present, that's not what the evidence has shown. So we came at this with an open mind, we investigated, and based on what we learned from the witnesses who were there, we decided those are the same witnesses that would testify at trial if we did go to trial.
Did you speak with the individual that was hit, and did he confirm that it was an open palm?
Well, there's two. One, he is now a criminal defendant, and I guess we haven't really talked about the events leading up to the actual call. So he was threatening, and I think he actually assaulted the lifeguard, and that's why GPD was called down to respond. So he has defense counsel, and at this point, I don't know how much they would want to cooperate with an investigation of the officer.
You have not spoken?
They have an attorney, so no, we have not spoken to them. Other questions?
Yes. I'm sorry, could you just rewind this whole thing about resisting arrest with the guy who had the handcuffs on?
The use of force is justified. You have to show that it's excessive. So if someone is kicking or pushing or trying to struggle to get into a police car, the law authorizes a police officer to use reasonable force to effectuate an arrest.
So he kicked the car, and then he started to walk toward the car. He kicked the car, then started to walk toward the car, and then Joey Uggan hit his abdomen. Is there
I mean, the
anything that-
video shows what a portion of what had happened. But if when you are able to review the reports, you will see that this was just one part of the individual who was arrested, not trying to avoid getting put into the police car. So the officer at that time thought in order to get him into the car, he needed to do it as a distraction technique, and that's exactly what he did.
So this is a judgment call on the part of the Attorney General's office to not take this to trial. But, I mean, you could take this to trial. You could ask a grand jury to indict based on the evidence that there already is, right?
Ethically, you would not pursue a case if you do not feel as though you could prove beyond a reasonable doubt at trial the offense that is at stake. So if we look at, if we do not feel confident we could prove our case beyond a reasonable doubt at trial with admissible evidence, then you would not pursue charges.
I know Prosecutor Peter Santos no longer is with the Attorney General's office, right?
What's that?
I'm sorry, so
Peter Santos, the prosecutor, the one who sent the magistrate's complaint to the
if
judge.
there's a question related to the presentation today, are there any?
Yeah, he was the original prosecutor on this, Joey, on the guy who was hit. And there was a magistrate's report that was issued, and Peter Santos was the one who issued it, and it described the events of what happened. Wouldn't that be correct?
I'm sorry, so you're asking about we're not going to comment on an ongoing criminal case against an individual who was the victim in this case.
Well, this is not about the victim, this is about, because the events of the officer hitting the victim were described in the magistrate's complaint against that.
I'm not sure if you missed the part. We did our own independent investigation. So our investigators went out and interviewed themselves, all of the officers who were present. So they did not rely, or our investigation is not based on any reports that were submitted at the time of a magistrate's complaint.
Okay. Is it common procedure for the Attorney General's office to decide not to pursue cases without talking to the victim or the alleged victim? Because you noted that this victim may be a defendant in a separate case, but you've also noted that you don't speak towards any ongoing investigations or whatnot, but then we also have the saying that innocent until proven guilty. So even though the individual struck in this video is a defendant in another case, and they do have legal counsel, why hasn't your office taken the steps to reach out to this victim's legal counsel to get his side of the story?
So going back to the initial comment about the role of our office, we represent the people of Guam, and victim input is essential and something that we always practice as part of our office. But the filing of charges is something that needs to be done under our own ethical standards. So ethically, we cannot file charges that we do not believe we could prove beyond a reasonable doubt at trial. Okay, so even if a victim were to say, well, I know you can't prove this, but I want you to file charges, we are not bound to follow the victim's input. We are ethically required not to file charges at that point.
Well, how do you explain other charges then that have been filed before a grand jury that were not enough probable cause?
Well, the grand jury function is that the grand jury will decide whether or not there's probable cause to proceed, and that's when you would get an indictment or a true bill.
But if you
So-
haven't spoke to the victim, how can you determine if there's probable cause or not?
That is one of our functions, is to determine whether or not we believe we can prove a case beyond a reasonable doubt.
But without speaking to the victim?
Even without speaking to a victim, you can look at what the facts are and what the evidence shows and know, again, I think that people don't understand what beyond a reasonable doubt means. It is the highest burden of proof under the law. So it is not, well, I think it doesn't look good, or I think, it's not if it's an I think, you have not met your burden. So if you can look at the facts that have been presented and know there's reasonable doubt based on the witnesses that you've interviewed, you would not file charges because this comes back to our office. You will get upset if we file all these cases that get dismissed out or we get acquittals, and then you're like, okay, the AG's office is filing too many cases, you're overcharging, you're doing all these things. We're trying to train our prosecutors to file what they believe they can prove. That is their job, and that is a decision that they have to make on a case-by-case basis, so I can't speak to one grand jury versus another grand jury. That is what a prosecutor is supposed to do. They're supposed to look at the facts, look at the investigation, and make a determination whether or not they believe they could prove at trial beyond a reasonable doubt a crime. If they do not believe that, then they should not file charges.
So then it's whether the prosecutor believes that they can win the case beyond a reasonable doubt.
Whether they can prove a case beyond a reasonable doubt. Yes.
And how do you bring rape charges to trial when it's one person's word against another?
Because you will believe a victim.
So
And a
it's
victim's
about-
statement that they have been sexually assaulted,
So then the Attorney General's office believes Officer
The-
Joey Ugin.
there is always going to, every case is going to be different, but we would not refuse to charge a case because the evidence was a victim statement.
But isn't that essentially what a rape charge?
That's what I'm saying. It's going to depend on the case, but if you're saying someone came in and reported a rape call, I think we're getting a little bit off of where we need to be.
So
So
why
are there
not
other
put it in
questions
front
about?
of a grand jury and let them decide?
Because we have made a determination based on the investigation that we could not prove beyond a reasonable doubt. So even presenting to the grand jury, you have an ethical obligation to only present that which you believe you could prove beyond a reasonable doubt.
Give them what's there. Why not?
That's your position. Are there other questions?
So just to clarify, you did speak with Officer Ugin?
Yes. He was interviewed as part of the investigation.
Are there any other questions that we haven't touched on?
Do you have any message to the people of Guam who might be upset about this decision?
Do I have any
A
message
for,
to?
any of our viewers who might be upset about this decision?
Mm.
Anything to allay their concerns about police corruption or police brutality in the community?
This kind of ties into the impeachment trial. It's, Senator Romney said, do what is right and let the consequence follow. I mean, this is what the right thing to do is. We've evaluated the case. We've made a determination. We cannot prove this case beyond a reasonable doubt. And if people are upset that we are doing our jobs, then there's not really much we can do. Thank you.